Nimeona amegotwa nini.
All right, good afternoon. Good afternoon, members. And thank you for joining us for this session. My name is Laban Joroge. I'll be moderating the session. And welcome to this virtual session. Welcome to the Public Service Superannuation Scheme. This afternoon, this virtual session is geared towards interacting with you, our members, primarily on two documents: the Public Service Superannuation Scheme Amendment Bill of 2024 and the PSSS Regulations 2024. Over the last week, we have been around the country. We have been to the Western region. We have been to the Eastern region, interacting with our members and interacting with the general public on these two documents and getting their views. So this is part of public participation. And if you read a schedule, if you saw a schedule that we published in the newspapers a couple of weeks ago, we had scheduled to have this virtual sensitization today at 1 p.m. So thank you for joining us. I want to acknowledge the presence of our trustees who have joined us for this virtual session. I noticed we had Dr. Kiprono around. So thank you, and again, acknowledging that we have the blessings of our trustees who have joined us, and some of whom will be speaking during this session as we share with you what is in the proposed amendments. Again, also, by way of announcement, we have an email to which members can share their comments on the two documents. So during this session, and I think before end of day today, we had set the deadline as at 4th of September, but we have extended that window to allow more members to share their feedback on this. So the email is publicparticipation@pssf.go.ke. So members who have feedback on these documents can share their feedback with us through through that email. So we don't intend to keep you for long. In about an hour, 45 minutes, we should be done with this exercise. We have structured this presentation in 3 sections. So the first section of this engagement will have some remarks by one of our senior team members. And then we'll have a presentation on the introduction to the scheme by, again, one of the team members. And then we'll have a presentation on the amendment bill, and a presentation on the regulations 2024 by our Corporation Secretary, Madam Angela Kipto. So at this point, ladies and gentlemen, allow me to invite Mr. Michael Kagika, who is the chairman of the multi-agency committee that has been spearheading this exercise over the last couple of months. So Mr. Kagika, please make some opening remarks, and thank you.
Very well. Thank you, Mr. Joroge, and I'm also pleased to join in today's conversation. So allow me to and then proceed to say our distinguished colleagues in the public service, the chairperson of the Public Services Superannuation Scheme and the trustee scheme, the chief executive officer of the PSSS, stakeholders, and all participants who are from across the country. I am honored to welcome you to this virtual public participation forum. As the Director of Pensions and the chairperson of the task force responsible for drafting the Public Service Amendment Bill 2024 and the accompanying Services Superannuation Scheme Regulations 2024, I extend my heartfelt thanks to each one for taking the time to engage in this important discussion, even in a virtual setting. Though we may be separated by distance today, we are united by a common goal, and that goal is to shape the future of retirement benefits for public servants across Kenya. The Public Service Pension Scheme was established with the aim of providing equitable and uniform standards for retirement benefits to all public servants. With the proposed amendments and regulations, we are seeking to further enhance the system, ensuring that it delivers even better outcomes for our distinguished members. This forum provides an opportunity for every participant to actively contribute to affirming or refining, rather, the framework of the retirement benefits of public servants. Whether you are joining us from Nairobi, Kisumu, Garissa, Lamu, Eldoret, Lodwar, or any other part of Kenya, your voice is crucial to this process. Post amendments to the bill and the proposed not just about accidents. They are about the future of our dedicated public servants, ensuring they retire with dignity and security. Indeed, that has always been our wish, and that is what we work for. The Pensions Department and in the National Treasury Track, we want to ensure there is dignity in retirement. And the same mantra runs through with the public service superannuations. We understand that pensions and benefits directly affect the rights and livelihoods of millions of Kenyans, and why we are
Apologies, members. I think we lost Mr. Kagika, but he's back. Mr. Kagika, if you can hear us, we lost you at some point. Please unmute your mic, sir.
Laban, am I audible now?
Yes, we can hear you now.
Okay.
Proceed.
And my apologies, therefore. So allow me, therefore, to just say that the amendments and regulations we are discussing today are designed to improve the administration and payment mechanisms of retirement benefits. And our goal is to ensure that every public servant, regardless of where they serve, can look forward for a secure and dignified retirement. We do understand that pensions and retirement benefits directly affect lives and livelihoods of millions of Kenyans. And that is why the feedback that we make today is essential. Having said this, I easily can recall the many expectations that retiring people have to receive their retirement dues in good time. And indeed, this is therefore the reason why the PSSS aims to provide that assurance to ask questions and your insights that will help us create a system that will stand the test of time. Your contributions will help ensure that the public service fund team continues to serve the best interests of all members. I thank you all once again for your time, your engagement, and I do pray that your commitment to this process will bear us the fruits that we seek. I look therefore forward to a productive and collaborative discussion. As we have been advised, those of us who are able to email our questions, let's feel free to do so. May God bless you all, and let's work together to strengthen the future of public service retirement benefits. With that, I declare this forum of public participation virtually open and give back the microphone to the moderator. Asanteni sana.
Asante Director, for that wonderful opening remarks and for officially declaring this virtual public participation open. Members, you may take note that we are also recording this engagement. So we'll share with you this recording, and this will also be uploaded on our YouTube platform. So in future, should you want to make reference to what was discussed in this forum, that will be available on our YouTube platform and also on our other social platforms. Thank you. So at this point, I want to invite Douglas, who is one of the members of the Secretariat, just to give us a brief overview or background of this process and also on the structure of the PSSS. And then invite Angela Kipto, our Corporation Secretary, who will make a presentation on the amendment bill and the regulations. Asante, over to you, Douglas.
Thank you, Njoroge, and thank you, Director Pensions, for opening this forum. The Director Pensions is the chairperson of the Multi-Agency Task Force. We appreciate your guidance, especially on this process since it started in 2022, November. Now, I wish to share the governance structure and the legal framework of the institution, Public Service Foundation Scheme. It's good for members to know who PSSS is. So I wish to welcome all members and stakeholders to this forum as we go through this important exercise to make services to members easier and the best, for them to have the best experience. So I will go through PSSS, who we are, the legal framework, and then the governance structure. So the Public Service Foundation Scheme was enacted through an act of parliament, that is the Public Service Superannuation Scheme Act, Cap 189A, that was enacted in 2012. The act established a defined contributory pension scheme for employees in the public sector, that is the teachers employed by TSC, civil servants under the Public Service Commission, and disciplined services personnel. When I say disciplined services personnel, I mean the employees serving in the Kenya Police Service, Kenya Prison Service, and National Youth Service. We currently have a membership of 443,639. This contributory scheme commenced on 1st January 2021. So we are regulated through these different statutes. We start with the Constitution of Kenya 2010, the PSSS Act, Cap 189A. We also regulated by the Retirement Benefits Authority through the RBA Act, Cap 197, and its attendant regulations. We also align ourselves to relevant circulars and other related statutes and regulations for this industry. The governance structure of the scheme, we have trustees at the apex, but then this scheme we know was established through an act of parliament, so the sponsor is government as represented by National Treasury. So we have trustees as appointed as per Section 10 of the PSSS Act, and we have a CEO appointed as per Section 20 of the PSSS Act, and a secretariat that serves under the CEO as we report to the Board of Trustees. The scheme is also governed under the regulations of RBA, which provide that the scheme or the trustees should appoint service providers. We have the fund manager, custodians, and also fund administrator. The fund manager is Gen Africa Asset Managers. We have 3 custodians, who is NCBA Bank, CFC Stanbic, and also Cooperative Bank. And the fund administrator is CPF Financial Services Limited. So those are the 3 key service providers that serves our members as we endeavor to serve members better. So the composition of those trustees appointed as per Section 10 is as follows. We have a chairperson appointed as per that section, and the chairperson is Wycliffe Wangamati. We also have a nominee from the PS Treasury. We also have a nominee from the Public Service Commission. We have a nominee from Teacher Service Commission, a nominee from Public Service Ministry. We have Inspector General, National Police Service, and we have unions also. We have a nominee from Kenya National Union of Teachers, a nominee from Kenya Union of Post-Primary Education Teachers, and also a nominee from the Union of Kenya Civil Servants. And currently, the nominee from the Union of Civil Servants is serving as the Vice Chair of the Board of Trustees. The key service providers, we've already looked at them. We also have the independent auditor. Currently, the scheme is audited by the Auditor General as provided for in our Act. So we got to this point, especially today, the culmination of public participation for these forums, the virtual forum. We've done other regions starting from last week. We've gone through Kakamega, Kisumu, Eldoret, Nakuru, Mombasa, Embu, Nyeri, Garissa, and yesterday we were in Nairobi, Jericho Social Hall, and participants have been giving their views on how best we can amend this law and the draft regulations to serve members better. So the multi-agency task force, which was appointed by the CS National Treasury, on the advice of the PSSS Board of Trustees, commenced its work in November 2022. And they've finally now come up with a draft Regulations 2024 and also their PSSS Amendment Bill of 2024. Our stakeholders, these regulations 2024 are to operationalize the PSSS Act Cap 189A, which was enacted in 2012. So we have the act, but we didn't have regulations so as we know how to serve members, because the act tells us what to do, but then the regulations will tell us how to do it. So those regulations are for the act as is before the amendment. Then we have now the PSSS Amendment Bill 2024. Upon commencement of the scheme in 2021, we noted that several changes have happened within the retirement benefits industry, especially from the RBA perspective with its regulations. So we noted that the law, our PSSS Act, was not aligned with the regulators' regulations and also the best practice. So that is why now we are amending this bill, and with your proposals and views, then we'll be able to get a good document to serve members better. So this amendment bill and the regulations can be downloaded from the website as shown on my screen. That is www.psss.go.ke. So stakeholders, if you go to the information center of the website, you'll be able to download those two documents. And remember, you can always forward your views or comments to the public participation at pssf.go.ke. And during this presentation, or even after the presentation by the corporation secretary is done, or as they go on, you are allowed to give your comments in the chat platform, which will be handled in the question and answer, or as we respond to your remarks. So feel free to write until we are done, then we'll respond to that. So we are currently, the PSSS scheme is moved from Bima House to CBK Pension Towers. We are located on BK Pension Towers, first floor. That is the location of the PSSS. So should any member wish to reach out to us, that is the location of the offices. We also have contacts which can be accessed through our social media platforms. We have Facebook, we have Twitter, and other channels. So at this moment, I wish to invite the Corporation Secretary, who also serves as the Director Legal Services, to take you through first the regulations, the draft regulations. Thereafter, she will go through the amendment bill. Then after which we can now respond to your questions for clarifications, also look at the comments and proposals that you are making. Thank you.
Thank you.
Good morning, ladies and gentlemen. Okay, thank you very much for joining us in this session. So with the introduction that has already been given, I will move straight on to the presentations. First of the Public Service Superannuation Scheme Regulations 2024. Then I'll thereafter take you through the amendment bill. So to start us off, we have the Public Service Superannuation Scheme Regulations 2024, whose purpose is to give effect to the PSSS Act Cap 189A. And as you'll see, as I make my presentation, it provides details or steps that are necessary to effect the provisions of the Act. So to start us off, so we have cited this as the PSSS Regulations 2024, and we have a definition section that is under Regulation 2, where we have defined the Act to mean the Public Service Superannuation Scheme Act of Cap 189A. So basically, these are regulations to the PSSS Act Cap 189A. Now, we've also defined the term cabinet secretary because that term is used both in the regulations and in the act. And this refers to the cabinet secretary responsible for matters relating to finance. This is because PSSS is housed under the National Treasury. So the CS in charge of this scheme is the one relating, the one from the National Treasury. Next, we have defined the employer. Reason for this is this being a contributory scheme, the key players in the scheme are the employer and the employee. So we've sought to define who exactly an employer is, and for purposes of the Act and these regulations, the employer is the Teacher Service Commission, the National Police Service Commission, Public Service Commission, and any other employer that the Cabinet Secretary may determine to be a public service for the purposes of this Act. We've also defined other service, that is to mean any other service within the public service as defined in the Constitution. Sorry for that. Next, we've defined a retirement savings account. When Douglas was making his presentation, he explained to us the three key service providers, that is the administrator, the fund manager, and the custodian. And the retirement savings account is basically an account that is maintained by the administrator. And it's in this account that members' benefits are credited. And it's out of this account also that we are able to generate member statements that are issued to members annually. Next, we have defined trivial pension. And trivial basically means not substantial. So trivial pension in our case then is an amount which is considered small, too small to be paid on a monthly basis. And as a result, the law allows that such an amount be paid out in lump sum. The Retirement Benefits Authority prescribes from time to time how much is deemed to be trivial pension. And the amount right now is about 10,820. So that is the amount. If the monthly pension payments are below that amount prescribed by the Retirement Benefits Authority, then a member can be allowed to withdraw all his benefits in full upon retirement. So we've also explained the fact that it is the role of the Cabinet Secretary to determine any other service to be public service for purposes of this Act upon request by that other service in writing. This being PSSF, we basically manage the pension contributions of employees of the public service, but the Cabinet Secretary can also has the authority or the powers to determine any other service to be a public service for purposes of this Act. Now, having explained the fact that the crucial players in this industry, in this scheme are the employer and the employee, we've set out the obligations of both parties. So the obligations of every employer for purposes of these regulations are, first of all, to inform all eligible employees of their automatic membership to this scheme. And they should also provide information about the scheme and ensure that employees fill out and submit to us the membership enrollment form and the beneficiary nomination form. So these are two very critical documents that the employee will help coordinating their completion and submission to the scheme. Then we've also set out the roles and the general obligations of the member. And first of all, the member, upon joining the scheme, will be required to submit the member enrollment form and the beneficiary nomination form. So these are two crucial documents, as I mentioned earlier on, because the membership enrollment form will first of all provide us with all the data and all the details relating to the member. And the beneficiary nomination form will show in detail the people that the member would wish to be paid their retirement benefits in the event that the member passes on. And so the member should also review and update the beneficiary nomination form whenever the structure or the composition of their beneficiaries changes. This is also a very important role that the member has to continually play. Then the member is also expected to ensure that the employer deducts and remits the correct contribution to the scheme on a monthly basis. The contribution rates are right now at 7.5% of the basic salary for the member, that is for the employee, and 15% of the basic salary from the employer. So it's the responsibility of the member to ensure that this amount is deducted and remitted to the scheme. And we also provide annual statements, annual benefit statements to the members. So it's the obligation of the members, according to these regulations, to scrutinize the annual statements and to confirm that they are correct. In the event that there's any error, then the regulations require that the member notifies the scheme so that corrections can be effected. Then we also, it is also a responsibility of the members to attend the annual general meeting or even special general meetings that are called by the scheme from time to time. And this is a good platform for members to ask questions and to receive reports on the performance of the scheme. And that is why it is a key obligation of the members. We've also set out the obligations of the trustee, trustees. Douglas earlier on took us through what the trustees do, the composition, and also just a bit about what they do under the law. And so the regulations have set out here about 16 key roles of the Board of Trustees. So they actually play a very, very critical role in the administration and management of the scheme. So the roles are listed there, about 16 of them. And I would urge you participants to go through them so that you can get the information in more detail. And as you are informed, you will get these drafts, the draft bill and the draft regulations from our website, www.psss.go.ke. Go to Information Center and you'll be able to download these documents, www.psss.go.ke. Go to Information Center. So I move on, and our regulation 6.3, we provided here that the board may delegate any of these functions or powers to any more of its members. Currently, most of the powers of the board have been delegated to the secretariat, but only those powers, those are administrative powers. But we've made it very clear that the board shall not delegate the exercise of its discretionary power. The law provides that the trustees, in some instances, have discretionary power, but by law, discretionary power cannot be delegated. And that is what we've set to provide in the regulations. Next is regulation number 7 on the annual general meeting. And here we provided that the board shall hold an AGM once in every year. And the agenda has been set out. This agenda is aligned to the Retirement Benefits Act, and it includes a presentation of reports on the changes to the structure and structure of contributions and member benefits. We also receive a report of audited accounts, investments, and the net investment return that is declared by the trustees. Members also get an opportunity to ask their questions and to engage directly with the trustees. So as I said, the regulations generally provide a step-by-step way of doing things. And that is why here, for example, we've provided for the timelines for the issuance of the notice and what the agenda should contain. Now, we've also provided for the special general meeting. So at any time, the board is authorized to call or to convene an annual general meeting for urgent matters that may not await the annual general meeting. So we've also set out there step by step how the meeting is convened, from the issuance of notice up to the actual holding of the general meeting and the number of days involved in each of the activities. Next, we have provided for additional voluntary contributions. And here the regulations provide that a member may elect to pay AVCs to the scheme in addition to the mandatory contributions that I mentioned earlier on. In addition to the 7.5% that the member contributes, the employee may also pay an additional voluntary contribution, and but the government will not match that. Next, so we provided how exactly the member can go about making the additional voluntary contributions. There's a form that we provided in our website that is filled out, and then it's submitted to the scheme through the employer. and the member shall be at liberty to increase or to reduce or to even stop making the AVCs, depending on their situation and their priorities as well. I've already mentioned the retirement savings account, so that we defined earlier. So we've set out in regulation 10 this details relating to that retirement savings account. First of all, regarding the obligation of the board to ensure that the scheme administrator sets up and maintains the retirement savings account for every member. And so we've set out in the regulations what exactly the account shall contain, including the breakdown of the contributions, the retirement savings that have been transferred from other schemes, and also accrued benefits, and also accrued benefits. And then the board shall have the responsibility of ensuring that the information provided is up to date and it's accessible to the members at any given time. So next, we move on to regulation number 11, and that relates to withdrawal from the retirement savings account. And the law provides that a member may leave the employment, a member may be allowed to withdraw from the scheme, now depending on the circumstances that have already been provided. Withdrawal can be on grounds of normal retirement. It can also be on grounds of early retirement, or maybe ill health, or even immigration. If a person is leaving the country without the intention of coming back, then they can withdraw their benefits. So from each of those instances, we have clearly defined in the regulations what would be required to be provided by the member. So for instance, here a member will need to make a request and attach a copy of the national ID card and proof that they have exited public service. And once that request to withdraw has been received, then through the administrator, the board shall ensure that the payment is processed and the amount is paid out to the member within 30 days. Next, we talk about the transfer of benefits that is under regulation 12. So we provide for instances where a member may leave the employment of the public service and wishes to transfer their retirement savings to another registered scheme. So we've also listed the documents that would be required, so that apart from the request form, the member will also be required to provide their national ID, proof of exit from the public service, and the details of the new scheme that they'll be joining. And from there, we'll be able to transfer their savings within a period of 60 days. We have also provided for deferment of benefits. This is to cover for instances where a member may leave the public service, but then wishes to retain their benefits at PSSS. So in that case, a member will just fill a form that we'll provide, and the member may at any time, even if they'll have left their benefits in the scheme, they may at any time transfer those benefits to another scheme. So a portability of benefits here has been brought out very strongly. We've also made provision for instances where a member retires on attaining the mandatory retirement age. So this provides for the normal retirement. And in this case, we've provided the fact that an employer shall notify the scheme of the impending retirement at least 12 months before that date. And we've then provided, again, what the member would need to provide. There's the claim form, then the proof of retirement, the ID, and then for those who elected to join the scheme, because when the scheme came into operation in 2021, those who are aged above 45 had the option of either joining this PSSS or remaining in the old scheme. So for those who joined PSSS, they'd also be required to show proof of their election to join PSSF. The instances of early retirement have also been provided. I will not belabor that because in most instances the requirements are similar. So upon retirement, Regulation 16.1 provides for how exactly what retirement savings will be paid out to the members. So first of all, a member who has retired will be entitled to be paid up to a third of their retirement savings in lump sum. So it's up to a third, but a member may decide not to withdraw those retirement savings at all, so that they can just be getting the whole of it in monthly portions. So once the member has accessed the up to 1/3, the remaining 2/3 will be paid out to them periodically, that is on a monthly or quarterly basis, either through an income drawdown arrangement or through an annuity. That is an annuity is purchased from an insurance company, and out of there the member will continue receiving a monthly pension for life. But in the instances where the amount is deemed to be trivial, then the member may opt to receive all that amount in full as a lump sum. Then upon retirement, the member is also at liberty to withdraw all their additional voluntary contributions in full. So where a member dies in service, we've provided here that there'll be two key benefits that they will be receiving. The first benefit is the member's retirement savings. And so this shall be paid out to the beneficiaries. So the beneficiaries will be paid, will receive one, the member's retirement savings, and two, an insurance benefit that is drawn from the life insurance policy taken out by every employer. So the beneficiary will only need to notify the scheme. And okay, it can be through the employer because the member is in service. So this can come through the employer. They notify the scheme of the death of the member. And then a form will be required to be filled, actually ascertaining that the member has actually died. And that is the point at which the beneficiary form will come in handy, because it's the nomination of the member that will determine how exactly their retirement, their benefits will be paid out. And in the event that the member has not filled up the beneficiary nomination form, then the trustees are allowed by law to exercise discretion and determine who will be entitled to receive that money. But I think it's neater and it's advisable for all the members to just ensure that they've filled out the beneficiary nomination form and update it on a continuous basis whenever their family composition changes, to make it easier for their benefits to be paid out to the beneficiaries, and also to ensure that their wishes are met in the event that they pass on while in service. So from there, I'll move on to the benefits that is payable under life insurance. I've already mentioned the fact that every employer is required under the PSSS Act to take out a life insurance cover for their members, and therefore the payment will be made directly to the nominated beneficiaries in the event that the member dies in service. Now, I move on to Regulation 19, and this one touches on the benefits that accrued before commencement of the PSSS Act. As we've been told, the PSSS Act, much as it was enacted in the year 2012, it came into operation in 2021. And some of the members who joined PSSS were already members of the defined benefit scheme. So under Regulation 19, we've provided that for the benefits that accrued under the Pensions Act, Chapter 189, the government shall determine the value of those benefits through an actuarial valuation, and there will be an increment rate that is proposed at the rate of 5% for those benefits, and the amount that has been computed will be communicated to each of the members concerned through what is called a letter of recognition. And those amounts will be paid out to the member upon exit from service. So once a member, say, exits through any of the options I had provided earlier on, then the member will be eligible to receive their accrued benefits from the DB scheme, and they'll receive the share of their contributions, the retirement savings, from the PSSS, that is the DC, the defined contributory portion. And finally, on the regulations, we have made provision for dispute resolution. here it is recognized that disputes may arise from time to time, maybe between the members and the scheme relating to how their contributions have been managed. And in this case, we provided that any dispute that arises shall be resolved in the first instance by the Board of Trustees. However, if a member still feels aggrieved by the decision of the Board of Trustees, then they shall have recourse to the Retirement Benefits Authority. This is in accordance with Section 46 and 48 of the Retirement Benefits Act that provides that a member may make an application for review to the CEO of the Retirement Benefits Authority, and that can also be escalated to the RBA tribunal in case it's not settled. And any matter that is not addressed by these regulations, we've made a general provision here that they shall be dealt in accordance with the general instructions that are issued by the board. The board has broad powers, the board has discretionary powers to determine all matters relating to the scheme. And therefore, if in the event that there are gaps in these regulations, then the board should also be able to deal with those matters. But then the board cannot just exercise their discretion any manner they want. We've provided the regulations that it can only be exercised subject to the Constitution and the law. So that is all about the draft PSSS regulations. I will move on to the draft act so that once I'm done with both presentations, then we can take in questions. So you'll now allow me to share the draft PSSS bill. So just to be very clear, the regulations I've just taken you through are in respect of the PSSS Act, Chapter 189A, as currently drafted and as we are currently implementing. So the amendments that we propose, the amendments that I'm going to read out here are the ones that we're proposing to Chapter 189A to just align them to the Retirement Benefits Act and to best practice in retirement, it's also aligned to the best practice in the retirement sector. And to start us off, we have made some additions to the definition section. If you go to the PSSS Act, Chapter 189A, under Section 2, we have interpretation. We have the interpretation section where we have defined a number of terms. So the first proposal that we seek to make is to amend the definition of the administrator, because currently we've just defined administrator to mean a body corporate or a person appointed by the board under Section 35, but we've sought to broaden that definition and make it clearer that administrator means a body corporate or an employee of the fund appointed by the board as such under Section 35 of the Act. Now, so this is just in line with the provisions of the Retirement Benefits Act, which recognize that an administrator can be a body corporate or an employee of the fund. And allow me, or a natural person. And allow me to also make it clear that save for this, for the definition of an administrator, which can mean either a body corporate or a natural person, the other service providers have to be body corporates, and that is how they've been defined. So both the fund manager and the custodian have to be body corporates. So that is where we need to draw a distinction. We have also made a provision for the term beneficiary. The Act currently does not make any definition or even provision for beneficiary, but the current trend is that a beneficiary is important in the administration of benefits. And so while the current Act currently just provides for a dependent, the dependent can only be understood in a very narrow sense. And that is why we propose to bring in the definition of a beneficiary, which is broader and includes both a dependent and any other person that may be nominated by the member in writing and who will be entitled to receive benefits from the scheme. And I keep repeating that is why it's very important for members to nominate beneficiaries, because this is actually the person, is not the dependent who receives benefit from the scheme, but it is the person who has been nominated by the member that is the beneficiary. We've also defined a deferred member, and we didn't have this provision currently. We don't have this provision currently in CAP 189A. So the deferred member here is a member who may have left the pensionable services of an employer, or that is of the public service, but has left all or part of their benefits still in PSSS. So they are also recognized as members. We've also defined an employer, because the term is currently missing in the Act, and had already mentioned who the employer is. So the TSC, the National Police Service Commission, Public Service Commission, and any other employer that the Cabinet Secretary may determine to be a public service for purposes of this Act. Next, we go to Part 2 of the Act, and this is the part at Section 3 that establishes the Public Service Superannuation Scheme. And so this does not change, but the reason that we have it here is the fact that under Section 3, we have the Public Service Superannuation Scheme established, and under Section 9, we have the Public Service Superannuation Fund established. So we have sought that we retain one term just for purposes of consistency. We retain the use of either the scheme, the proposal was that we use either the scheme, that is PSSS or PSSF. So the proposal currently is that the scheme be known as the Public Service Superannuation Scheme. However, we'll also be taking views from the members on whether we should use PSSS or PSSF, that is Public Service Superannuation Fund. So the views of the members would be important. So it's just about semantics, it's just about the term. It doesn't really it doesn't affect the root of what PSSS does. So next, under Section 5.3, we have talked about member. 5.3 talks about who a member is and at what point a member will be deemed to have left service. But that provision currently does not make provision for a deferred member. So initially it just read that any member who has retired either normally or has taken a normal retirement shall cease to be a member of the scheme. But then here, a deferred member, someone might leave, but because they've not attained retirement age, they've opted to leave their benefits with us, then that member will not cease to be a member of the scheme. They'll only cease being active members of the scheme, but they will remain as deferred members of the scheme. Next, I move to Section 6.1, and that is the provision that talks about the contribution rates. Currently, the law requires that the member contributes or the employee contributes the scheme at the rate of 7.5%. And as I said earlier, the employer matches that by making a 15% contribution. Now, here we propose that to create flexibility, this section be amended to read that every member shall contribute to the scheme at a rate not less than 7.5%. This is to create flexibility in the event that there's need to enhance the rate of contribution. The law and there's a government circular that allows that contributions should not, member contributions can go all the way up to 10%. So to have that flexibility of changing it whenever there's need, we introduce that the phrase not less than. But then there is a proviso to that increment can only be made upon consultation with the board and the members. So the members have to give a nod to it, and the board also have to give a nod before the changes can be effected. And the changes can only be effected by the Cabinet Secretary by a notice in the Gazette. Another provision that is very important to make here is the fact that while these contributions should be made monthly, where the employer fails to deduct these contributions, then the sum, that amount that is due within the month, shall be recovered in the subsequent month, and there shall be a penalty to that at the rate of the return that the scheme received the previous financial year. So this is just to make sure that the employer or the member does not lose out in their benefits, because any moment we receive contributions, every month we receive contributions, they are invested, they are forwarded to the fund manager for investment. So in a case where contributions are delayed, we then propose that the amount has to be paid out the subsequent month, and the element of there's a penalty, that interest has to be paid out in addition to the monthly contribution. Next, we go to the provision of under section 6, subsection 4, still relating to contributions. And the Act, as I mentioned earlier, currently only makes provision for the government, but does not really make provision for the employer. So here we've sought to bring out a distinction between the role of the government and the role of the employer. So the Act currently, as section 6.4, provides that the government shall take out a life insurance policy for the members. But in our view, it's not the role of the government to take out the life insurance policy. It is the role of the employer. And that is why we propose that we delete reference to government and instead substitute that with employer, so that it's clear that it is the role of the employer to take out the life insurance policy in respect of every employee. Next, still on the distinct role between the government and the employer, under section 7.2, we had the provision to the effect that a member shall instruct the government to deduct AVCs, additional voluntary contribution, from his monthly emoluments. But the amendment we seek to provide is that it is the role of the employer to deduct, not the role of the government. So in this case, then we're proposing that the member should instruct the employer to deduct the AVCs from his monthly pay. Still distinguishing the role of the government from that of the employer is under section 8A, where we had indicated earlier that the government shall deduct a member's monthly contribution from the member's monthly salary. So we have proposed a deletion of that section on the basis that it's not the role of the government to deduct the member's portion of contribution. That is the role of the employer. So section 8A then, if the proposal goes through, section 8A will have the effect of deleting deleting the requirement for the government to deduct a member's monthly contribution from the member's earnings. And with that, we've provided clear obligations of the employer. And the first one would be that the employer deducts and remits to the scheme, of course, to the custodian, that is the member's monthly contribution, not less than 10 working days from the end of the month. And secondly, the employer shall ensure that the government's contribution is remitted in accordance with the law. So the employer's responsibility is well cut out to deduct and remit, and also ensure that the government contribution is remitted. So the government, on the other part, will deduct and remit the employer's portion to the scheme. We have then provided under what we now call section 8C, the public service superannuation scheme fund. So this is not a legal entity. It's only a fund which shall be managed and operated by the board. And it's into this fund that contributions shall be paid, and it's out of this fund that member benefits shall be paid. So next we move. So next we see here that we've mentioned the Public Service Superannuation Scheme Board of Trustees. Initially, the Act currently provides for the Public Service Superannuation Fund Board of Trustees, but in light of the explanation that I made earlier on, that we are proposing a consistency in the use of scheme and fund. So this will be moved to Section 3, and that is why we are saying that we're proposing the repeal of Section 9. So we'll now have the Public Service Superannuation Scheme Board of Trustees and not the Public Service Superannuation Fund Board of Trustees. But then depending on the views that we receive from the members, if we decide to adopt fund and not scheme, then this will be the Public Service Superannuation Fund Board of Trustees. I hope that is clear. So I move on to Section 10, which brings out the composition. It establishes the Board of Trustees and indicates their composition. So under Section 10, we have proposed to have an additional 2 trustees. So currently we have 9 trustees, that is the chairman and 8 other trustees, 5 representing the employer and 3 representing the employee. Now, the proposal that we're making here is that we have 2 additional trustees, and this shall be member representatives. The reason for this is under the Retirement Benefits Act, a defined contributory scheme is required to have representatives or trustees representing members who are not less than half of the entire board composition. So the member representative should not be less than a half of the entire member composition. But as we stand currently, the membership of the Board of Trustees is skewed more in favor of the employer. So the recommendation here to have 2 additional trustees will just be to ensure that we have at least an equal number of both the employer and the employees representatives, and without being in compliance with the requirement, with the Retirement Benefits Act. Next is an amendment to Section 13 about instances under which a trustee may be removed from office. And the Act has provided a number of instances, but the one we've given attention to is Section 13(2)(a), which provides that a member may be removed from being a trustee if he's been absent from a board from 3 consecutive board meetings. So we propose to align this with the Retirement Benefits Act that requires that a member may cease being a trustee or may be removed from office if they've been absent from 2 consecutive meetings of the board. This is just to ensure that the trustees are consistently present and available to participate in the deliberations of the board. The next one is on the remuneration or the allowances paid to the trustees. That is under Section 18 of the PSSS Act. The Act currently provides that the trustees shall be paid sitting allowances at the rates approved by the Cabinet Secretary from time to time. But we've also proposed to align this to the Retirement Benefits Act, which provides that the allowances of the trustees shall be approved by the members during a properly constituted general meeting after every 3 years. So the proposal here is to pass the obligation or the authority to the members to approve trustee remuneration every 3 years in alignment with the Retirement Benefits Act. Next is under Section 20 regarding the qualifications of a CEO. So Section 20 establishes the office of the Chief Executive Officer of PSSS, and it provides for the qualifications of the CEO. Currently, the qualifications are quite narrow. That is an expert in retirement benefits, accounting, finance, insurance, or banking. So the proposal here is to widen the pool of expertise from which we can draw the CEO, and to make it open-ended. The Act currently has made it closed-ended, which may not be very ideal. So the proposal we have is that so the qualification should include economics, auditing, HR, or any other relevant field. I think what is most critical is or any other relevant field, so that no qualified person will be closed out from being appointed the CEO of PSSS. Section 16 2 proposes to bring in a very important principle of law. The fact that, so section 16 talks about the delegation of the powers of the board. But then we have proposed a proviso here that the board shall not delegate its discretionary powers to any of its appointed agents. So this is just in keeping with the general principles of law. Next is section 25 on the vesting of member benefits. So currently, the Act provides that benefits derived from a member's contribution shall vest immediately in the member. But the benefits that are derived from the employer's contribution can only vest in the member, say 5 years from the date of the first contribution, and only 50% will vest in that 5th year, and the rest will vest periodically up to the 10th year. And that is not in line with the law, is not in keeping with constitutional provisions on the rights of a member to retirement benefits. It's also not in keeping with the Retirement Benefits Act, which requires that all our members accrued benefits, all accrued benefits shall vest immediately in the member. So this is just to comply with the requirements of the law that all accrued benefits shall vest immediately in the member. Then section 26 is the next one about access to retirement benefits. It's basically relates to preservation of benefits. Currently, the law provides that a member may withdraw his contribution and accrued benefits in full on leaving employment together with AVCs. But the law on retirement benefits makes a different provision, and we seek to align our act with the Retirement Benefits Act, which currently provides that a member will be entitled to only up to 50% of all his accrued benefits. But then instead of making that instead of making it cast on stone, because the Retirement Benefits Law also keeps changing from time to time, we proposed that then a member should be able to access accrued benefits in accordance with the Retirement Benefits Act, so that whenever the Retirement Benefits Act or changes on the access, we don't have to also amend our act. So we've just chosen to align it with the Retirement Benefits Act. Of course, we've also provided the fact that where a member is leaving the country without the intention of coming back, then they'll be entitled to all their accrued retirement savings. Section 27 and 28 relate to the access or withdrawal of benefits. So number one, we have provided for the fact that once a member has left service or has retired, then they can access their monthly pension either through an annuity purchased from the insurance company, or through an income drawdown plan. So we currently do not have provision for an income drawdown plan. We only have provision for an annuity. So this proposal seeks to bring in that aspect of access to retirement benefits through an income drawdown plan. And we have also provided under section 23(2)(a), this is a new section for situations where a member's benefits are determined to be trivial, in which case the member may opt to receive those benefits as a lump sum. Then for a member dying in service, the current provision under section 30 is that the administrator shall apply the entitlements of such a member under the life insurance policy. But then this is not the role of the administrator. So the proposal we seek to make here is that where a member dies in service, the board of trustees is the one to apply the accrued benefits now in favor of the beneficiaries of that deceased member. So it's just to bring in the fact that this is the role of the board and not the role of the administrator. And in this case, the benefits payable to the beneficiaries of a deceased member shall be paid out in full. So it may be accessed in full as a one-off lump sum to the beneficiaries. So that is the new provision that we're making under section 20, under number 25 here. Now, there's another provision that we're making that is under section 32(1) about a member. Now, the Act provides a member who was married at the date of retirement and of course dies in retirement. So we have proposed the deletion of this section. And the reason we have proposed the deletion is, first of all, the issue of marriage of a member does not really arise, because we are just talking about the member, and in the case of their death, we talk of their beneficiaries, and our beneficiaries do not, when we talk of beneficiaries, we don't look at whether or not the member was married at the time of death. And the reason we're also proposing deletion of this section is the fact that upon retirement, a member is already able to access, a member is already accessing their benefits either through the income drawdown or through an annuity. And earlier on, we've already provided for how the payments will be made out to their beneficiaries. So this provision in our case was superfluous because we've already made a provision for how benefits will be paid out upon the death of our member, whether active or retired. Then next, we move on to section 33 about transfer of service. And the Act currently, under section 33, provides that where a member transfers service within the public service or to a county government, then their retirement savings shall be maintained. But in this case, we propose that we delete the transfer, we omit transfer to a county government. The reason for this is that PSSS only handles or manages pension contributions, retirement contributions for employees drawn from the public service. So the employees of the county government already have their own pension schemes, which is also statutory in nature. And therefore, a member transferring their service to the county government will be subject then to the, or will be required to make their contribution to the pension schemes that have been established to manage the pension contributions of county government employees. Next is on the portability of benefits, that is under a new provision that we are numbering as section 33A. And currently we don't have provisions for transfer of retirement savings to another scheme. So we are proposing to make that provision that where a member exits the public service, then they'll have the liberty to transfer their savings to another registered scheme. So they cannot withdraw it for their own use, they can only transfer it to another registered scheme. So the next section, that is on section 35, 36, and 37, relate to our service providers. As we were earlier informed, we have 3 key service providers: the administrator, the fund manager, and the custodian, and they are engaged through a procurement process. So we propose to make amendments to the provision relating to these service providers to the effect that, number 1, their terms of appointment shall be determined by the board and set out in a written instrument. So this basically means that we should have a contract for each of the service providers that we've engaged. And secondly, that the term of each of these service providers shall not exceed 3 years and shall only be renewable subject to satisfactory performance. So this is just to make sure that all the service providers are able to perform satisfactorily and that the interests of the members are well secured. So the next is about the annual general meeting. Much as I've mentioned it earlier on as I was talking about the regulations, but it's also important to note that our Act currently does not have any provision on the annual general meeting. And so we propose here to introduce this new section as section 38A, that the board shall convene an annual general meeting within 6 months from the end of every financial year. And we shall convene and conduct these general meetings in accordance with the provisions of the Retirement Benefits Act. The Retirement Benefits Act has specified in great detail how an annual general meeting shall be held, what the agenda shall be, and the notice period that should be given for the AGM. So we propose to adhere to the provisions of RBA when it comes to convening and conducting an annual general meeting. The next one regards the administrative expenses of the scheme. And we are proposing that we make this provision that the board shall meet all the administrative expenses of the scheme from the scheme fund. We earlier mentioned the Public Service Superannuation Scheme Fund that will be managed by the Board of Trustees. And in this case, in the proposal is that this administrative expenses of PSSS shall be met out of that fund. And the administrative expenses shall not exceed 2% of the total scheme assets. But this amount will even reduce further from the 6th year to 1.5%. So this is just to ensure that we minimize the amounts we spend on administrative expenses. And the board is also given the authority to open an account from which these administrative expenses shall be defrayed. So moving on, under Section 40, currently, the Act provides that the board may invest surplus funds established in the accounts established by the board in securities approved by the Cabinet Secretary. And so we are proposing that this provision be deleted for the reason that the trustees have absolute authority to determine how scheme funds will be invested. And secondly, the Retirement Benefits Authority has provided very clear guidelines on how scheme funds should be invested. And so since we have those two key provisions, the Board of Trustees guided by the investment policy statement, and of course the oversight of the Retirement Benefits Authority, the Cabinet Secretary does not really have a role in determining how scheme funds may be invested. And that is why we are proposing deletion of that provision. Next is on the reserve account, where we currently have provided that there shall be maintained a reserve account into which shall be deposited various funds here that we've set or that we've listed. But the key phrase that we are noting here is the fact that there shall be maintained is vague, and it should be made clear that it is the responsibility of the board to maintain this reserve account. So instead of saying there shall be maintained a reserve account, we propose then to change it to read the board may maintain a reserve account to clearly apportion responsibility to the board. Next is a provision on the annual estimates. Of course, we've said that we replace scheme with fund, but as I said, we'll also take the views of the members on whether we can retain fund and not scheme. So here about the annual estimates or the annual budget, we said that this should be prepared at least 3 months before the commencement of the financial year. And we have provided the items that should be contained in the budget. That is, for example, the payment of the board and other operational expenses, payment of pension and gratuities for staff, maintenance of buildings, and even repairs and replacements of equipment. And so that just makes it very clear that we do not just spend out of no basis. There has to be a basis for our spending, and that should be captured in the annual budget. And next is the fact that the books of accounts of PSSS have to be kept. It is the responsibility of the board to make sure that the books are kept and that the records are proper. And for that reason, the board is required to cause these accounts to be audited. So currently the requirement is that these books of accounts be audited by the Auditor General in accordance with the Public Audit Act. We are proposing that these accounts be audited, not just by the by the Auditor General, but the trustees be given the liberty to also appoint an auditor and to appoint an external auditor. The reason for this proposal is the fact that the scheme under the Retirement Benefits Authority, the scheme has very tight timelines as to when the books of account should be audited and submitted to the authority. We actually have 3 months. Only it should be submitted to prepared, audited, and submitted to the Retirement Benefits Authority within 3 months from the end of the financial year. And most of the times, because of fact that the Auditor General runs on a schedule, the scheme may find itself in a situation where it's not able to comply with the timeline set by the regulator. So in that case, we're proposing that the trustees be given the liberty to also appoint to engage external auditors, of course, competitively through the procurement process. And the good thing about this is that the Retirement Benefits Authority also supervises the appointment of auditors, and they will have to approve the auditor appointed by the scheme. So that just makes it, so that just ensures that the auditors appointed by the board shall be above board and shall have been vetted and approved by the Retirement Benefits Authority. And as a scheme, we'll also be able to meet the tight timelines that have been set by the regulator in submission for submission of the annual of the audited accounts. Next is on Section 45 of the PSSS Act, that is on actuarial valuation of the fund. The Act currently provides that we conduct an actuarial valuation of the fund periodically. However, we've proposed that this provision be deleted. Reason being that from the retirement benefits perspective, actuarial valuation is mandatory for defined benefits schemes. However, for defined contributory schemes like PSSS, that is not a mandatory requirement. It is not a necessary thing to do because the member contributions are well known. We know of the 7.5 employee portion, the 15% employer portion, and the fact that the interest will be credited to the member's account on an annual basis. So since that amount due to a member in the DC scheme is very well defined, then there will be no need for an actuarial valuation. And mostly actuarial valuation in the DB scheme is usually also meant to determine the funding level of the scheme. So in this case, that funding level is not really a requirement for the DC schemes. And that is why we're saying that this will be an unnecessary activity and it will also occasion an unnecessary expense to the scheme. Next, I go on to the provision under Section 49 of the Act regarding circumstances under which, again, a person, maybe a trustee or an employee, may be removed from or may cease being one. And here, the provision was that where an employee or a trustee is convicted of an offense, then the minister, that is the cabinet secretary, may cause that person to be removed. However, in our view, it should not be upon the cabinet secretary to determine the removal of that officer or that trustee. Instead, it should be automatic that once a person has been convicted of an offense and they've been taken through the criminal trial process and found guilty, then the person shall automatically cease to be a member. If it's a trustee, then that person shall automatically cease to be a trustee. It should not depend on the decision of the cabinet secretary. Next is on Section 50. This section relates to benefits that accrued before commencement of the PSSS Act. I mentioned this when I was talking about the regulations. And so just as a recap, I will just mention the fact that the proposal we're seeking to make here is to bring clarity, because at the moment, Section 50 is not really clear on what becomes on the contribution and whose responsibility it is to pay out these accrued benefits. So we seek to bring clarity to that provision. first of all, by saying that all benefits that accrued before commencement of the PSSS Act, whether they accrued by virtue of the Pensions Act, Chapter 189, or the Widows and Children's Act, that is a Cap 195, then shall accrue and shall be payable under those respective acts. So any benefits accruing under Cap 189 shall be payable in Cap 189. Benefits accruing under the Widows and Children's Pension Scheme shall be payable under the children's under Cap 195. And of course, benefits that shall have accrued under the PSSS Act shall also be payable under the PSSS Act. But then just for clarity on the way forward, so all those benefits that are accrued under the Cap 189 shall be, the government shall have a role in making sure that they are determined, and through a letter of recognition, the members will be notified of the amounts or of the benefits that are due to them. And we're proposing that the government shall issue these letters of recognition within 6 months from the date of commencement of this act. And so those benefits, after they've been determined and recognized in a letter, shall not be payable immediately. They'll be deferred until the member attains the retirement age. They can only be paid out if a member dies in service. Next is a general provision relating to compliance with the provisions of this Act. We recognize the fact that because of circumstances beyond anyone's control, the fund or the Board of Trustees might not be able to discharge or to implement some of the provisions of this Act. And this therefore gives the Cabinet Secretary, with the concurrence of the Retirement Benefits Authority to exempt the trustees from complying with those specific provisions, or to even extend the times. So assuming, for example, timelines of 3 months or 6 months have been provided for accomplishment of a certain task, then the CS, with the concurrence of RBA, will also have authority to extend the time required for compliance. And just a case in point or just trying to paint this scenario and make it clearer, is that during the COVID season, schemes were not able to have their accounts audited and submitted to RBA within 3 months. Schemes were also not able to hold AGMs, and boards were also not able. Trustees are required to meet on a quarterly basis, but in this instance, they were not able to meet because of the circumstances arising at that point. And RBA issued guidelines on how exactly the members of schemes were expected to conduct business at that point. And in fact, times were extended. The times for holding annual general meetings were extended. Some schemes were even exempted from making member contributions until such a time that they stabilize. So to cover for such instances, we propose to bring in this new act of exemption of the board and extension of time. Next is exemptions from the Unclaimed Financial Assets Act. And here we propose that the Unclaimed Financial Assets Act shall not apply to the scheme. The provision that we were more keen about is the requirement that any unclaimed benefit shall be transferred to UFA if any benefits remain unclaimed for a period of 2 years, then it is incumbent upon the trustees to transfer them to UFA. So in this case, we're proposing that instead of transferring them to UFA, that those amounts should remain in the scheme, they continue being invested by the trustees, because as trustees, they have a fiduciary role, and they'll actually ensure the safekeeping of these finances until such a time that the members or their beneficiaries come to claim it. So we feel that the money is safe with the trustees, and therefore the provisions of Unclaimed Financial Assets Act should not apply to PSSS. Then we've also proposed a transitional provision, mainly because we have, if you can recall, we proposed a change in the composition of the Board of Trustees. And the proposal here is that these changes, in the event that these amendments go through immediately, then the members currently serving should not be affected by the changes until the end of their term. So they should be able to serve until they complete their respective terms. Then finally, we have proposed an amendment to the State Corporations Act because currently PSSS is established by an act of parliament, and by virtue of that, we are a state corporation. However, at the same time, being a retirement scheme, benefit scheme, we are subject to the provisions of the Retirement Benefits Act. And in most instances as a scheme, we found ourselves in a situation where the two acts are conflicting, and we are not able to fully comply, or we are not certain which one we should comply with and which one we should not, we should leave out. So we propose then that to bring clarity and to ensure that we are always fully compliant, then we should align ourselves with the provisions of the Retirement Benefits Act, since we are a retirement benefits scheme. So in that case, that we propose that the State Corporations Act shall not apply to the public service superannuation scheme. So those are the amendments that we're proposing to make. And I think I'll hand over to the moderator to take up your comments and your questions and your requests for clarifications. Thank you so much for your time and for listening to me.
Thank you, Angela, for that detailed presentation on the regulations and the amendment bill. So at this point, ladies and gentlemen, we are going to take contributions from the membership in the form of questions or comments on what has been proposed in the two documents. So I'd request that you, for any members who have comments or questions, to raise their hand so that we can usher you to ask your question or make your contribution. We are also receiving questions through the chat, so at some point I'll invite Douglas Asanyo to also guide us in answering those questions. So members, if you have questions or contributions, please raise your hand so that we can usher you to ask those questions. If you have any questions, you could as well unmute your mic and proceed. So as we wait for that, Douglas, are you with us? We can take a few questions.
I am.
In the chat. There's a question from Atito Japheth, who asks, at what point will the government write this letter? So Atito is asking, at what point will the government write the letters as proposed in the amendments? Douglas,
What we've provided for is that upon commencement, after now the amendments have gone through, the government will have 6 months to finalize that and issue those recognition letters to members who transited from the non-contributory scheme to PSSS.
Thank you, Douglas. Martha Nyambura asks, how long does it take for one to access the fund after retirement? So Martha, your retirement benefits will be paid to you within 30 days after retirement. We're taking questions. So there's a question that was raised by Washera Minor, which Douglas has addressed, but I would want you to also address it in the main forum for the benefit of others. So she asked, for those who are under the national scheme, but got devolved to counties, now they are either in lab fund or lab trust. Explain that so that, and on whether they are still members of PSSS.
Thank you, Njoroge, for that. When the scheme PSSS was commencing, a circular by the head of public service was issued, and it communicated who is going to be a member of this scheme. And the county government's employee who were initially employed by national government under the Public Service Commission but their services were transferred to the county governments due to devolution, then are still members of PSSS. That is why for those who didn't join the PSSS and had services transferred, their benefits are still paid by the National Treasury for those who are above 45 and didn't join the scheme. So they are still members of PSSS.
Thank you, Douglas. There's a question again by Martha. This is on the investment income. She asked what happens to the gains made by the fund. Do they trickle down to the member?
Thank you, Njoroge. For the benefit of everyone, once investments are done and the auditor has audited the financial books, an income is the return on investment is pronounced by the Board of Trustees, and that income is distributed to each member to their respective retirement savings account each financial year. So once we declare, we make sure that that is distributed to all the members' retirement savings accounts.
Thank you, Douglas. We have Christine. Christine, proceed and ask your question or comment. Christine? Christine, please unmute your mic and proceed.
Oh, yes. I hope I'm audible enough. I'm
Yes, you
asking
are.
two questions. One, there's the form that was supposed to be filled by members who are out, who joined the scheme. Like we started getting deductions from our pay slips without knowing, but now we know it's about the PSSS fund. So where can we get the forms? How can we fill them? And that is the first question. The second question, I'm calling to ask about those who are working with the national government before devolution and had not done 10 years with the national government. I've seen the question being addressed quite well with Mr. Senyo. I hope I'm pronouncing the name right. But again, upon inquiring, maybe we need an indulgence also from the RBA, because there was that information that those who had not completed 10 years had not yet been included in the whatever that contributory fund. Sorry, I hope you understand my question. So how can individuals, like how can people know within those who had not completed 10 years before joining the scheme, I mean before devolution, do they have anything, and how do we go about it? Because there's that gray area that has not yet been addressed fully. Thank you.
Thank you, Christine. Douglas, would you want to address that and maybe also talk about the different forms that are available to members and where they can access those forms?
Thank you. The forms of the scheme can be downloaded from the download section of the PSSS website, www.psss.go.ke. You will get all those forms there, from the beneficiary nomination form, additional voluntary contribution form, and even the benefits claim form. So whenever you need services from the scheme, in those manner, you can always download the forms and complete and submit them through your employer. And on eligibility to pension, yes, it is 10 years, but it's 10 years service, but not service to the scheme. What the law provides, as long as you are still within the public service, if you served under the public service administered now in the non-contributory pension scheme administered under the Pensions Act Cap 189, and you are still in the services of your employer, that is the public sector, then that period is still cumulative. It's about the pensionable period. If you are still in service, that will also count for you to be pensionable. Even if you served 2 years in the old scheme and then PSSS happened, you are still eligible for the accrued benefits from the non-contributory scheme.
Thank you, Douglas. I think as part of that response to Christine, her question was particular to the member enrollment form. She says that she was automatically enrolled to the scheme in 2021. She didn't fill in any form. Douglas, she didn't fill any form. Can she fill in the member enrollment form at this point, 3 years into the scheme?
We had two categories of members or employees joining PSSS. Those who were below 45 years of age, as at 1st January 2021, became automatic members by commencement of the Act. Those who were above 45 had an option to complete an option form to join PSSS and start contributing. And once a member joins the PSSS, then they cease being members of the non-contributory scheme. So for those who are below 45, at that time, they were not required to complete any form because the Act didn't specify. But now that members are already on board and we're requesting them to nominate beneficiaries, we have a form. It's called Enrollment and Beneficiary Nomination Form. So that takes care of that. So those who are below 45 happened to be members because of the Act. There was no choice. The choice was only for those who are above 45 years of age as at 1st January 2021.
Thank you, Douglas. There's James Ogweno is asking on the chat, can a member be allowed to contribute more than the normal contribution of 7.5% of their basic salary? Maybe talk about the addition of voluntary contributions, Douglas, in the context of the circular issued by the National Treasury in July on the registration and management of public service retirement benefit scheme, particularly on the contributions by the employer and the employee.
Yes, a member is allowed to boost their savings towards retirement by doing additional voluntary contributions. That is done by a member downloading a form, completing it, and submitting it to their employer, who will, in effect, deduct those additional voluntary contributions and forward or remit to the scheme. These additional voluntary contributions are only deducted from the member as they wish, not as a percentage, but an absolute figure. And as Angela said, these amounts can be increased, decreased, or actually even stopped when a member is unable to continue with that. What I want to insist on is that whenever a member is doing additional voluntary contributions, the employer is not obligated or will not match those contributions. This is individual and it's for purposes of improving or boosting retirement savings for that particular member. The Treasury Circular that was issued on 10th July 2024 only talks of the limits of contributions for the schemes, pension schemes, with a minimum of 6% to 10% for the employee and 12% to 20% for the employers. I hope that is clear.
Yes, thank you, Douglas. Chepkwani asks, what will happen to their deductions? I think this is on the issue of non-remittance. What will happen to deductions done on member payslip but not remitted to the scheme by the employer? His question is, he says that, for instance, he has around 10 months that were affected but were not reflected in their statement. Maybe Chepkwani, because that seems to be a personal issue, could you write to us on email info@pssf.go.ke to allow us to confirm the discrepancy in your statements and advise further. But Douglas, could you talk about issues of remittances and where we are, and how does the scheme handle the issue of non-remittance?
As per the Act, employers are obligated. They have the obligations of ensuring that they deduct the members, the pension contribution from members and remit to the scheme by the 10th day of the subsequent month. So, and then the National Treasury will do the 15% for the employer contribution, which is also remitted to the scheme, and it has been up to date. For the employers who fail to remit, the scheme tries to reconcile the accounts and also follow up with the employers who have either deducted and not remitted to the scheme so that there are no delays. And where delays are, employers are always requested to remit the delayed remittances with the interest as prescribed in the PSSS Act.
Thank you, Douglas. How do I access my statement? That is Eric Omondi Okech. Eric, you can access your statement through the member portal. So you can access the member portal via www.members.psss.or.ke. So when you log into that portal, you have an option of seeing your contribution statements, and you can also get detailed statements, audited statements for the financial years 2022 and 2023 that also indicates your investment income, the investment income that you gained during that period. Thank you, members. I see we are joined by our CEO, Dr. Jonah Ayabei. I'll allow him to also make some remarks at this point. Asante, karibu daktari. Daktari, can you hear us? Thank you. Seems the CEO is having some technical challenge, but he'll join us and make some remarks before the end of the meeting. So we'll share the link with you, David, www.members.psss.or.ke. That is the member portal that you can use to download your statements as we have indicated. So Martha is asking, is it possible for a member to be getting the statements of his or her account? Martha, as we indicated, you can get your statement on the member portal. Thank you, members. At this point, I'll invite our CEO, Dr. Jonah Ayabei, who is on the line, to make some remarks and some final remarks as we end this virtual public participation forum. Daktari, please unmute your mic.
Unmute. Hello?
Hello.
Joroke, I'm not very sure whether you can hear me.
Yes, we can hear you, Daktari. Proceed.
Okay. Good afternoon, everyone. Good afternoon, members who have managed to join. Mine is to really appreciate the feedback that is coming forth during this very important exercise for Public Service Valuation Act. We have come back to you to really get your comments on how the legal provisions that are being amended will be fitting to the necessary requirements or expectation of all the members of the public. So I really want to appreciate all of you who managed to join and appreciate the team who have been coordinating this. And we want to wish you all well and let you know that this is really our scheme, and we want that we get it right in terms of the amendments to the benefit of each and every member. We do exist to serve the members, and in everything that we work around is to really add value to the members. So thank you very much, all of you. I wish you well in this afternoon and in your other endeavors. God bless.
Asante sana, CEO. Members, at this point, we've come to the end of this virtual public participation forum. We would want you to take note that you can always engage us through the various options that we have shared on the screen. We are available on call. You can always call the office via the number 0746 111 777. You can write to us on email info@pssf.go.ke. And you can also access our website on that link, psss.go.ke. So you'll get all information that you need on the scheme on that website. You can also write to us on WhatsApp for a more personalized engagement through the number 0783 111 777. In conclusion, just to mention that we are still receiving your contributions on these two documents via email. As had been shared earlier, it's public participation at pssf.go.ke. Asanteni sana, members, ladies and gentlemen, for that engaging session. We wish you a wonderful afternoon, and may God bless you.